times a year, children in America are charged with crimes in juvenile court. The overwhelming majority of these charges are for nonviolent offenses, cases like trespass, property destruction, smoking marijuana, underage drinking, fighting in school, or maybe talking back in school. The kind of behavior that is pretty normal for middle and high school age students, but is disproportionately policed and prosecuted against children of color and children in low-income communities. America's juvenile courts were built with good intentions. But in our system of justice, America's children need good lawyers. It's common sense, but it's not common practice. We're here today to discuss innovations. The juvenile court system was itself created as an innovation. Back in the early 1900s, the big idea was to treat children like children, to guide and rehabilitate them and remove them from the harmful environment of adult criminal courts, jails, and prisons. But by the 1960s, it was clear the reality of the juvenile court experience was not living up to this ideal. Children, in fact, were experiencing the worst of both worlds. They were being punished harshly like adults, but without the constitutional protections of adults. And by 1967, the United States Supreme Court heard the case called In Re Gault. Jerry Gault was a 15-year-old boy in Arizona. He was charged with making a prank phone call to a neighbor. And for this alleged delinquency, Jerry was sentenced to years in a juvenile prison, without notice of the charges against him, without an opportunity to cross-examine witnesses, and without the representation of a defense attorney at trial. Considering this case, the Supreme Court said, good intentions are not an adequate substitute for a fair hearing. And under our Constitution, the court said, the condition of being a boy does not justify a kangaroo court. And in the landmark decision In Re Gault, the Supreme Court held that children are entitled to due process of law, and that includes the right to a defense attorney. Common sense, but not common practice. Children in America need good lawyers, effective juvenile defenders, to both protect their rights and help them become successful adults. We live in a country that incarcerates more children than any other nation in the world, that subjects children to solitary confinement, strip searches, shackling. We station police officers and make arrests, sometimes violent arrests, in our schools. And against this backdrop, children need zealous advocacy in two critical ways: to present the child's voice in court. Juvenile defenders build attorney-client relationships. They understand the circumstances of their client's life. They help guide their client through the process, help them make important decisions, and understand the consequences of those decisions. Juvenile defenders also ensure that the proceedings are fair. They investigate the case, they negotiate with the prosecutor, they'll take the case to trial or do everything they can to ensure that the outcome is appropriate for that child in that case. And in this sense, juvenile defenders provide critical checks and balances, both for the individual child client and for the juvenile justice system as a whole. Common sense, but not common practice. I work for the National Juvenile Defender Center, and we conduct statewide assessments to assess and examine children's access to counsel and quality of representation. And in my home state of Colorado, an assessment a massive gap in juvenile defense services. We learned that in 45%, almost half of all juvenile delinquency cases, children went through the entire proceeding without ever having a defense attorney. To understand how this was happening, we took to court watching. We went into the juvenile courts, we sat in the rows alongside children and families, and we watched. There was no defense attorney in the room, there was no judge in the room at first, but there was a prosecutor. And the prosecutor called each child's name and handed nearly every family a 7-page packet of legal paperwork, offering to resolve the case right there and then if the child simply waived his or her rights and pled guilty. The prosecutor advised if the child wanted a lawyer, they would have to come back on another court date, and in the meantime, go to the public defender's office and fill out an application. To a parent, hearing your child is going home on probation can sound like a pretty good deal when you're looking at missing 3 days' work just to get your child a lawyer. So we sat as the judge came out and watched an assembly line of case processing. One by one, children and families stood before the judge, waived their rights, signed all that legal paperwork, entered pleas of guilty, with no one investigating their case, no one talking to them about their life, no one negotiating whether mentoring or diversion might be appropriate, and no one advising the family about the long-term consequences of a juvenile adjudication. How that trespass case might affect their college application, or how that marijuana plea might get the whole family kicked out of their apartment, or how pleading guilty to that fight in school might get them expelled or kicked off the sports team. That's not rehabilitation. That's not justice. But it's a scene that plays out state after state across our country. We know access to justice is about access to an attorney themselves, but it's also about the quality of that attorney's representation. And in this country, we deny children quality of representation when the legal profession treats juvenile court like a training ground, a place for new lawyers to learn how to become a defense attorney before they take on the responsibility of representing adults. And so in some places where children do get lawyers, their lawyer may have very little interest in juvenile defense, or not enough time in a juvenile court rotation to master the ins and outs of the specialized nature of juvenile court practice. Compare this to the medical profession. We don't let doctors practice on children before they're qualified to treat adult patients. To the contrary, we take our children to specialists called pediatricians. And just like the specialized care of a pediatrician, children who are prosecuted in America need the specialized care of a juvenile defender, someone who understands the characteristics of youth development, someone who knows the ins and outs of the system. It is common sense. So what's next? Next year, we will commemorate the 50th anniversary of the In re Gault decision. And this is an opportunity for all of us to stand together for children's rights. Community, courts, policymakers. When we work together, we can, and in many places are, making progress to ensure children's right to counsel. And when we make common practice, early access to a lawyer for all children, and specialization in juvenile defense, we will be innovative. America's children are overdue for due process. Let's not wait another 50 years before we ensure children's constitutional rights. I invite you to join our GALT at 50 campaign and be a champion for children's right to counsel, because children in America need good lawyers. Thank you.